Further hearing the appeal of the Small Saint Spring Park Parochial Church Council against the church.
Good morning, lords. There's a little bit of an echo. There is. Which is a little annoying.
Yes, I wonder what that is. There's an echo. Can we address
it? Let me try see if it's still there. Just about. Can your lordships cope with that?
Yes. We'll see if we can have it addressed, but why not proceed in the meantime?
Yeah.
We'll always stand a little further away.
Yeah.
Not too far back.
Okay. Well, my lords, I have to confess, I had a very restless night. Let me explain why. I don't think I've done justice to Reverend Yvonne's case or the PCC in one regard. I made a mistake yesterday and I wish to correct that mistake. It will take a couple of minutes.
Please do.
If you will permit me to do so. I know how important this case is to my client, so let me put that right. It relates to Lord Legate's point when you were asking me about the notice and on the jurisdictional point, and I just want to correct something I said in relation to the Peas and Carter. 6 short points. Number 1, the test is how a reasonable recipient, bearing in mind the context, would have understood the notice. That's number 1. Number 2, this is set out in P's, and that's at paragraph 39, and for your lordship's reference, that's 2286. And the test is how, quote, would be understood by a reasonable recipient reading it in context. And as was said in New Bold at paragraph 60, and the reference to paragraph 60 of New Bold is 2165, quote, the statutory or contractual requirement may cast light on both the intention of the given the notice and the reasonable understanding of the recipient. Such was the case in Manai Investment Company Limited against Eagle Star Life Assurance, in which the parties' actual or deemed knowledge, and I'm going to come back to that word deemed in a moment, of the requirements of the lease affected the consequences of the notice, including a date that did not comply with the contractual requirement. Number 3. So, the question, and this is the submission, the question is not what this registrar actually understood in reality. That's not the question. The question is what a reasonable recipient, i.e. a reasonable registrar, would have understood. That's the third submission. Number 4. It's an objective test, not subjective, and this is where I went wrong. Because I was suggesting, wrongly, that it would depend on whether the registrar in this case had been sent the documents, the emails showing who Lee Day and Co. were representing both the PCC and Reverend Carter. No, it's an objective test, and I'm just going to expand upon that in a moment. So my submission is a reasonable registrar has to be imputed with the knowledge of the proceedings below. And I say that...
Sorry.
Yeah, so I'll repeat that. A reasonable registrar has to be imputed with the knowledge of the proceedings below. That is inherent, you get that from the statutory requirement of paragraph 3 of Schedule 2, which we were looking at yesterday. And you'll remember that's the paragraph where the registrar has to satisfy themselves that the proposed appellant has duly made written representations. And I say it's my submission that that duty can only be performed by finding out in detail what happened in the proceedings below. And a reasonable registrar would therefore have done so. So it doesn't matter whether this registrar actually did. It's what a reasonable registrar would have done. And that brings me on to my fifth submission. It's therefore irrelevant that there's no evidence before us that the registrar actually found out what happened in the proceedings. What matters is what a reasonable registrar would have understood, having the knowledge of the surrounding context that a reasonable registrar would have had. And can I take you to Newbold? I don't mean right now, but when you get your opportunity. Paragraph 60, page 2165, refers to, quote, the party's actual or deemed knowledge of the requirements of the, and in that case they were talking about a lease. So I'm not relying on the actual, I'm relying on the deemed knowledge, the deemed imputement. And so that brings me to my final point. In this case, we say that a reasonable registrar would have informed themselves sufficiently about the proceedings to have known that Lee Day acted in the proceedings below, and as I say, and as I suggested to you, and this is where I went wrong yesterday, when I was talking about the correspondence between the commissioners and Lee Day, where it was clear that Lee Day were acting for both the PCC and Reverend Clark. My submission is this: not that this registrar actually had actual knowledge of that, but a reasonable registrar, if they were complying with Schedule 3, Paragraph 2, would be deemed to have, because they have to satisfy themselves that the representations were duly made, would have seen Lee Day were acting for both appellants. And this ties in with the point I was making yesterday, because the solicitors hadn't said we're no longer acting for both parties. A reasonable registrar would conclude that the solicitors are still on the record. So that's a suspicion. I can't put it any higher than that. But it leads on to this point, and I'm looking at you, Lord.
But if it's any comfort to you, Mr. Johnson, the argument you've just articulated is exactly the argument I understood you to be making yesterday.
That does comfort me.
But it might be said that on this line of reasoning, all the registrar needed to know was whether written representations had been duly made on the draft scheme, and that's it. But you say she should be deemed to know more than that.
Yeah. Particularly on the because context is important, and I said context in this case is that you had in the prior proceedings, if the registrar if a reasonable registrar is satisfying themselves pursuant to paragraph 2 of Schedule 3 of sorry, the other way around. Sorry, yeah. Then they have to satisfy you that you're a proper person to be making representations.
The big step in your argument is going from what a reasonable person in the position of the registrar would understand the notice to signify, and what such a person might then do if they didn't understand it to be on behalf of particular people, to find out who it was on behalf of, which is a separate question.
That's a separate. Well, yeah. What I say though, in this context, where the issue is, has been raised by my learned friend, well, were they acting for one party, the other party, both parties, somebody completely different? Where you've got a reasonable registrar looking at the looking at the proceedings below, that's the context. They will see that the solicitors are acting for both parties. And
but you wouldn't expect somebody just on receiving the notice in the registrar's position to know who had acted at an oral hearing in the preliminary proceedings. It's not something we reasonably...
No, I agree. I agree.
The most you could say is that if they didn't, they wouldn't know. So they might find out. Whether it's their responsibility to find out if they haven't been told is that it's a separate... That's all.
Lord Legger, I'm pushing back on that, and let me push back on that for this reason, because in this case, it comes back to the schedule and the provisions, paragraph 3 of Schedule 2, where the registrar, a reasonable registrar, has to satisfy themselves that the proposed appellant has duly made written representation, and to do that...
We don't expect them to have done that before they get the communication, so that when it arrives, they although it doesn't say on whose behalf it's sent, they know, because they've been busy going around the country at oral hearings just in case there's an intention...
But that's not how it works.
A request to is made. But we're talking about the knowledge they have, or should be taken to have when they get the communication.
I say that the context of this is part and parcel of the reasonable registrar satisfying themselves as to who the parties were in the courts below. Anyway, I put... There's a consequence that flows from this, though, and can I just deal with that? And this isn't a submission, but this is what the board, should be doing. And can I just explain that? Because just assume for one moment, right, I know you've got to decide it, but just assume for one moment that my submission is correct, okay? That notice had been given. What does that mean in relation to the proceedings and what we're doing now, here, right now, today? Effectively, what we are saying is that the registrar would need now to issue a notice, because that hasn't been done. You, the board, could direct the registrar to do this. The statutory function is vested in the registrar, not you, the board. But the board could express a view that Reverend Yvonne and or the PCC, but let's just concentrate on Reverend Yvonne for the moment, because the PCC standing is an issue, whereas Reverend Yvonne having standing is not an issue. So you could direct that. We would then need to refile our application for leave to appeal. And what I say, these proceedings are not redundant, because what could happen, and I'm just giving you this so that there isn't a problem down the road. If you find favour in my argument, you issue that direction, we would then refile our application for leave to appeal. We would do so, or undertake to do so, on exactly the same terms that you're hearing the argument now. The only change would be a change on the date of the application that we submit. You would then need to formally re-grant leave to appeal, but the hearing of the merits that you're hearing now need not be heard again, because all you would need to do as the board would simply indicate at some future date, when you've determined this appeal, whether the appeal was successful or not. So that would be the answer to the fact that the notice hadn't been issued. Because the alternative would be, if I'm right, if my submission is right and the notice hasn't been issued, then these proceedings now, which are taking place, if you didn't direct the registrar to issue the notice, we would be putting in another appeal, and that can't be right. and that would be a complete waste of time.
Yeah, well, one could, if necessary, reconvene the same panel to hear if there were any supplementary submissions.
That's another way. That is another way of doing
One
it.
wouldn't have to rehear the whole hearing on the merits, if you're correct.
I mean, I wonder whether actually it would be necessary even to go through that step of directing the issue of a notice. I mean, if we were satisfied that the registrar should have issued a notice, and you rightly say that raises the question whether that would be a notice in respect of the Reverend Yvonne Clark and PCC. But if we were satisfied that that step should have been taken, given all the steps that have subsequently been taken, I think we would be able to proceed on the basis that it had been issued. I don't think it would be necessary to go right back and do all these steps again.
I just flag it.
Thank you.
Yeah. I mean, basically, if we have jurisdiction to hear the appeal, which is what we're debating at this stage, then I would have thought that we are masters of the procedure here, and put it colloquially, we could cut to the chase since you've been given permission to appeal on the merits, and we can see that if your argument succeeds, that the registrar should have issued a notice. I would have thought that we could just, in effect, make an order either deeming the notice to be served or making all those things happen immediately and collapsing it all, so that this is an effective hearing. Speaking for myself,
I would have thought you might even be able to imply that the registrar had notified the parties out of the subsequent communication. Also another way of getting there. Anyway, one way or another.
I think the key
maybe
point,
the least of your
key
problems.
point is if we have jurisdiction, we are the masters of our own procedure,
It's okay.
and we can get round the problem.
Okay. My Lords, I'm going to sit down because, in fairness to my friend, she should have an opportunity to respond. I don't know when.
Oh, yes. Well, we can do that in the substantive submission.
So be it.
That is okay. Yes.
I'm grateful. Okay, can I continue where I left off last night then, coming back to the merits? Ambit of Article 8. I turn briefly to whether the facts are within the ambit of Article 8. I accept that the PCC as a body corporate can't have Article 8 rights in its own right, but the facts of this case certainly have more than a tenuous link with Reverend Clark's private life. Now, I note the three criteria set out in the Royal Cayman Islands case, which you'll find at page 3037. It actually starts at 3018, but the reference I want to take you to is paragraph 72. So paragraph 72 in the Royal Cayman Island case, which is, you'll find at 3037 going over to 3038. So can I flag that for you? And the effect on the applicant's inner circle, opportunity to establish and develop relationships with others.
So which paragraph are you reading?
72, my Lord.
72, thank you.
Page 3037 going over to 3038.
Thank you very much.
So, the effect on the applicant's inner circle, her opportunity to establish and develop relationships with others, and her social and professional reputation. We say in this case, the scheme will not only mean the loss of Reverend Clark's mission and ministry, but the loss of the parish community of All Saints. It will also mean the loss of Reverend Clark's home, the parsonage house. And although she can, of course, seek another role within the Church of England, it's obviously unlikely she will be able to remain in the Spring Park Shirley area. In the absence of a role and a home in that area, and furthermore, as I made clear yesterday, the position of a parish priest is not just a job, but it's a religious vocation, to use Lord Hodges' expression yesterday, which I agreed with, which is naturally core to a person's social identity. And as I've already mentioned, Reverend Clark spoke powerfully in her representations about the importance of her calling to her personally. And the circumstances of the scheme, which rests on criticisms of Reverend Clark's financial management of the parish, are certainly liable to damage her social and professional reputation. Now,
but your claim isn't based, is it, on discrimination against Reverend Clark as an individual?
no, that's correct. But the point I'm making, and this ties in with what I was saying yesterday, Reverend Clark as an individual, you'll remember the quote, she missions and she's part of the community herself as the
I understand your submission yesterday, she's one of the people affected.
Yeah.
That's rather different.
No,
and therefore can bring a claim, and therefore as a victim.
Lord, it's that, but in addition to that, I say that Reverend Clark and her mission within the parish is also she's part of the whole. She's indivisible from All Saints, and I say that's an important part of her both Article 8 and Article 9 victim status. But look, let me see if I can put it in another way. I've already highlighted.
It's a bit superfluous because you've got Article 9 ambit already, haven't you?
I know, maybe I don't need. Maybe I don't need both.
Well, I don't think you do need both, but.
I mean, can I? My understanding is that, correct me if I'm wrong, that you're saying that this is arguably an interference with her personal life, because she's being deprived of her home, the parsonage house. She's being deprived of her position as the vicar of All Saints and all that goes with that. I mean, is that the way in which you put the Article
Yes.
8 case? Yes.
Yes.
I see.
I don't see how that connects with your discrimination argument.
Well, I don't. Yes, I see.
Well,
I mean, I didn't understand it necessarily to be a discriminatory argument, but
I thought it was just to get you in the ambit of Article 8 as the platform then for a discrimination argument, was what I understand.
under Article, which I will come to and develop. But what I'm saying is, Lord Sells, you're right. I'm saying yes. If it be challenged that Article 8, that we can come within the ambit of Article 8, I say we come within the ambit of Article 8 for the reasons I've just articulated.
Right. And when we come on to the discrimination part of the argument, we might need to look at what you say the discrimination is, because that might have some relevance to the basis on which you're bringing yourself within the ambit. But at all events, you're concentrating on ambit at the moment.
That's all. Yeah, exactly. Thank you.
It is put against you by Miss Wakefield that the link between the operation of the scheme and the Reverend Clark's private life is very tenuous, and she founds on the comments of Lord Stevens in the Royal Cayman Islands case at 89 and following. That, I think, was a case about mandatory retirement.
So, my Lord,
that was a case about mandatory retirement, I think. How would you distinguish your case from the approach of the board in Royal Cayman Islands?
Just bear with me, Lord. I'm calling up my response on that.
Surely. I'm sorry if I'm taking things out of context. It's just you were referring to Royal Cayman Islands, so I thought this might be an appropriate point to look at the look at what was said there.
Yeah.
This is at page 3043.
I'm sorry, my lords, just do forgive me.
If you wish to come back to it in your reply submission,
Can I do so?
yes, please. But if you can flag it up as something.
I will do.
to cover.
All right. Can you make a note of that?
But as Lord Leggett says, in any event, you have the Article 9 concession, so you may not have to battle too hard over Article 8.
So, what I'd like to touch upon next, if I may, I want to turn to the evidence that the scheme will have a disproportionate effect on the black community.
Can I just be clear at the outset? Your argument that the people discriminated against, is that right, are non-white people living within the parish? Is that right? Or I just want to be clear who the group are that you say are the victims of discrimination, and who the comparator group is.
Well, I'm coming right onto that, and I've got statistics for you. But in essence, there's a large black and brown community within the All Saints Spring Park parish.
And they're the group treated unfavourably.
Exactly.
And who are the group?
White.
Within the same parish?
Within the same parish. And I'm going to explore that and develop that.
So your argument will be that getting rid of the parish
has a disproportionate impact on black and brown people in comparison to white people in the area.
Who will also be losing the parish.
Who will also be losing the parish. And I'll explain why. Yeah?
Yes, thank you.
So, let me now then turn to the evidence that it will have a disproportionate impact on that group. Yes? And the test is neatly summarised in the BIAO against Denmark, BIAO, and you'll find that in your bundles. It starts at 3345, and the paragraph that I want to take you to is paragraph 103, and you'll find that paragraph at 3381 to 3382. And the quote that I would like to take you to in that paragraph is, quote, "A difference in treatment may take the form of disproportionately prejudicial effects of a general policy or measure which, though couched in neutral terms, discriminates against a group." And I've just identified the group for you.
Sorry, can I just...
That's a definition of indirect discrimination.
Yes, exactly. Such a situation may amount to indirect discrimination, which does not necessarily require discriminatory intent.
Yes, the point I was making, and now see was made over the page.
Yeah. So the question here, therefore, is whether this scheme, though couched in neutral terms, has a disproportionately prejudicial effect on the group of people that I've identified.
Yes.
So let's delve into the heart of this case and the impact of the scheme proposed by the commissioners. Now, it's one that essentially shuts down Reverend Clark's parish. Our contention is that this scheme, while seemingly neutral on the surface, carries indirect discriminatory effects. Put simply, the decisions made in forming this scheme unfairly target not only Reverend Clark, but the community she faithfully serves. Why? Because if you scrutinise this plan, it becomes evident that its ramifications disproportionately affect the people that I've identified. Let me break that down.
It's hard to say that a Christian mission is aimed or should as it were, advantage one community over another. You would have thought it should be equally available to all. Your claim is that black and brown people have more to lose than white people.
My lord,
from the shutting down of the parish.
No, that's not what that's not. I'm saying this scheme in relation to this parish will disproportionately affect black and brown people in this parish, and I'm going to explain. My lord, you raise a really, really important point, because what I'm not saying, and I want to be clear on this, I'm not saying that just because you've got a black vicar, there should be a black vicar that missions to this parish. My argument with respect is not as simple as that. It's more nuanced, and may I pick up the gauntlet and explore why, and I'm about to do so, why that interpretation is not what I'm saying. So I have that in mind.
Yes, please continue, because I'm aware of the shortage of your time. You've obviously used some of your time reprising the jurisdiction point, so we want you to develop your submission on the merits. Thank you.
And can I also say this? The arguments that I'm about to go through are highly relevant and very similar to the arguments on ground 3, so there's not going to be repetition.
Yeah, thank you.
My argument is very simple. Firstly, the abolition of All Saints will have a detrimental impact on the existing congregation, as well as to the communities to which it ministers, in particular the Shrublands estate. Now, there is copious witness evidence supporting that submission, which I'm going to take you through shortly. So that's number one. Number two. Second, the existing congregation of All Saints and the communities to which it ministers are disproportionately black and brown, both to the relative demographics of the area and relative to the demographics of the other 2 affected parishes. Now, if I can establish both of these propositions, and I would have established that the scheme does have a disproportionate impact on the group I've identified. Let me do so. Now, I don't think it's really disputed that the existing congregation of All Saints is disproportionately black and brown, but I'll take your lordships briefly to the figures. The statistics about All Saints congregation put forward by Reverend Clark and the PCC before the DMPC was also before the commissioners, and you'll find those stats at 286 in the bundle. Can I ask you to turn that up? That's 286 of the bundle. They're all set out there. I'm just going to run through them very quickly, but I've given you the reference. From the adults, black men account for 40% of the total.
So can I just be clear what we're looking at here? This is looking at the electoral register of the district of the parish. Is that what these statistics are drawn from?
As I understand it, these are
the congregation.
This is the congregation.
Right.
This is the actual congregation that Reverend Clark put forward before the DMPC, and the church commissioners had this information before them. So this is our evidence.
Sorry, I hesitate to rise, but we don't think we did have this information before us. This was in front of the DMPC, but it wasn't repeated as part of our process. It's not a big point, but my learned friends made that submission twice now, so I thought I should correct it.
Well, this is the congregation. So, black men count for 40% of the total of the congregation, white men 10%. Black women aged between 29 to 35, about 20% of the total congregation. White women within the same group, 10%. Amongst women aged 40 to 65, 40% are Asian, 50% are black. The majority of the people, BAME people, using that from the wording, are shift workers, including nurses. Of those aged between 65 to 94 years of age, 40% are white women, 30% are black women, 10% are Asian women. Among children, 30% are black Caribbean, 40% are black African, 10% white, although some children are from mixed heritage. And you can read on. So we say, just in terms of the congregation, the impact on the group closing this parish is going to have a disproportionate effect on the group that I've identified than...
But it won't affect the black members of the congregation more than it affects the white members, will it?
It's 100% for all of them. I mean, to the extent that it's a detriment, and I'm readily accept as it is, to lose this parish ministry, each one of the congregants here will lose that. So it's 100% of the whites losing it and 100% of the black and browns losing it.
But in terms of the overall parish, because this is a parish that is within an area where there are three parishes, one being closed, this is a parish where there are more black and brown people than the other parishes, and we are saying that...
But your comparator group is not the other parishes. You've made it clear that it's white people within this parish.
No, it's white people within the three parishes.
Well, that's not what you told me earlier when I asked you the question.
Sorry.
We wanted to make quite clear what your position was, and you said it was within the parish that black people were treated less favourably than white people. If you're now making a different argument, then...
I think your written argument looks not only to the parish, but to the congregation, but to the wider community.
Yeah, that's the first point, and I'm sorry if I misled you. I didn't mean to. I didn't quite understand. But there are three other churches in this area.
Yes, different parishes.
Yeah, and. What the church commissioners are doing are closing this parish, keeping the other two parishes, and the other two parishes are predominantly white. And so therefore the impact of closing this parish, which is predominantly black, I say has a disproportionate impact.
Well, who are the groups now treated less favourably, and who are the group treated more favourably for this comparison?
Well, it's the same group, my lord. It's the same group. Is it
black people within all three parishes compared with white people within all three parishes?
Yes, because within all three parishes there are less black people going to the other two churches than there are in relation to this church. And therefore there is, when you look at the figures, a disproportionate impact on black and brown people.
Oh, right.
Yes, we have, I think, in the Statement of Facts and Issues at paragraph 11, which is page 947, the population statistics for the other parishes.
And in fact...
So you needn't take time going
No,
through them.
in fact, can I ask you also then just to look at paragraph 15 on page 949. And against that backdrop, so the question is...
Sorry, what was that reference again?
Paragraph 15 on page 949.
Thank you.
And that shows that well, you can read the stats for yourselves. And so the question is whether the abolition of All Saints will have a disproportionate impact on the group that I've identified relative to its impact on white people. And against that backdrop, I want to turn to the evidence supporting the submission that the abolition of All Saints will have a detrimental impact on the existing All Saints congregation and disproportionate on the local community that All Saints serves. And can I take you through some of the representations made that were made before the commissioners? And I'm going to do this quickly. I'm going to give you the references. So there's Kwame Sarpong at 252, where he says, quote, "The vicar and most of the members of the church are black. All Saints has given me the opportunity to grow and train as a leader and to be more effective in doing the work of God. The current PCC is inclusive and made up of all blacks, and this is helping us in leadership roles, and it's not just in the church but in our jobs in the community." Russell Leonard, page 257. "As a member of the black clergy, she's also in a position to empower the black laity and fellowship due to the mutual understanding of the BME culture, which is invaluable for the diversity of the Church of England." 316, Victoria Lever. "Before attending All Saints, I never really went to church, but attending All Saints and being a part of it, of such a welcoming community, has enabled me to gain a true understanding of my faith. Without All Saints and the vicar, I would not have found my faith. In doing so meant that my sons were christened and I myself confirmed. The church and the vicar are holding this community together. To take it away will leave this community with an empty hole that cannot be filled." Mohammed Barry at 319. "The removal of Reverend Yvonne will result in a deep-seated and detrimental change so that the black ethnic minority and minority people will become lost and forgotten people. Not only will they be forced to leave All Saints, but they will be forced to leave the Church of England and the church altogether." He went on to say at 320, "We have received excellent pastoral care. Reverend Yvonne was making contact using social media even before lockdown. Reverend Yvonne knew and understood the congregation and community so well that she was able to attract and address diversity and inclusiveness in such a seamless way that brought the people together as one." Alicia Barry, 321. "She has worked tirelessly to promote God and the church. The congregation love and appreciate her role as a vicar and pastor. She warned me, in the event of Reverend Clark's removal, quote, not only will people be forced to leave All Saints, but they'll be forced to leave the Church of England and the church altogether." Quarterly Family, 255, quote, "I've lived in Shirley for 18 years, and as a member of the community, I've noticed that the majority of the church members are of an ethnic minority group. I feel as though the representation of this group is important in Shirley, as the community as a whole is predominantly white. Therefore, it's nice to have a community at church which represents my family and I." Winston Thomas, page 434 to 436. "When Reverend Clark arrived at All Saints, there was a handful, if that many, of black women in the congregation, although many black people lived in the parish. By contrast, there were now more children of colour. BAME children were aspiring to be professionals. People from the estate on the wrong end of Bridle Road were serving on the PCC, assuming leadership roles in the community, and BAME men had started attending. While Shirley is a wealthy area, All Saints has always been a poor parish." Miriam, she doesn't give her surname, at 323. "Our church is very diverse and different from the two other Anglican churches in Shirley." Emma O'Sullivan, 327. "It's a beautiful church, a friendly community with a lovely mix of age groups. Yvonne is welcoming and knows her parishioners well. I feel that the Southwark Diocese would be doing a disservice to the people who attend by closing the church. Many of them, like me, have been a part of the community for a long time. It's hugely important to them." And at the hearing before the commissioners, my lords, Mr. Calvert-Williams at page 20 said that 70 to 80% of the kids from shrublands would go to All Saints. You see that paragraph 27. You'll see that paragraph 27 of the Statement of Reasons. and that All Saints was seen as a safe haven by many, including those running away from local cartels. You see that paragraph 29. My learned friend says that Mr. Williams' figures must be misstated or exaggerated, but the point here is that All Saints is engaged in active outreach to the Shrublands estate, and that is a theme which Mr. Williams elaborates on in his witness statement, which I'll take you to shortly. And let me take you straight to that. Pages 68 to 69 of the bundle, you'll see Mr. Calvert Williams' statement. He says that All Saints has always reached out and made poor people the focus of the mission. Poor people of the Shrublands estate are mainly from the black community. It's taken years of work to build trust and belief within the local community. The church has been responsive to issues in the black community through Windrush clinics, food banks, services which cater for the black community during the week. Mr. Williams works with people who have significant mental health problems and who are vulnerable, and he says, quote, "Seeing firsthand how All Saints has made them feel welcome at the church," he adds, "representation has been crucial to get people involved and feel welcome at the church. People feel more welcome at the church at All Saints because of where they come from. A lot of these issues come down to race. It's taken time to get the space where we can communicate the pain and the pressure that each of us is going through. That it's the atmosphere that has been created at All Saints due to the representation and trust that has been built by the PCC." And then finally, if I can take you to, penultimately, if I can take you to Winston Thomas's statement, 70 to 71.
Sorry, the page number?
70 to 71.
70 to 71, thank you.
She states that she joined the church in 1998. There were 5 black people in the church, all women including herself. She states, quote, "25 years later, we've built a congregation and PCC that is diverse and predominantly made up of minority ethnic people. This is reflective of the area that we serve. Shrublands estate is a working class area with a high minority ethnic population. The vicar and the PCC at All Saints have helped people to know their value in the Church of England and in society. We encourage people from the local community to become involved in the church, not only as congregants, but also as PCC members. People from minority ethnic background got involved in the Deanery Synod, Churches Together in Shirley, and roles in the Shirley Neighbourhood Scheme, for example. These were real positions of responsibility within the church and the local community." Critically, she states, "The vicar and the PCC at All Saints have helped people to know their value in the Church of England and society. With people seeing the first black deacon in the Church of England, they felt comfortable to get involved. As they saw people from a minority ethnic background getting involved, the church grew, became reflective of the area that we serve. People from minority ethnic backgrounds got involved in the deanery and so on." And then, can I come to the last witness statement that I would draw your attentions to? Robert Dubé, 72 to 73. He's a PCC member and former treasurer at All Saints and teacher of business and IT at a college in South London, who states, "The Anglican minority ethnic people in the area of Shirley have made All Saints their spiritual home. There is no church like All Saints in Shirley that caters for minority ethnic community." He states that All Saints built up this representation firstly through representation by bringing black people into the PCC, and that at first people were surprised to see black members of the PCC, but this surprise turned into trust, a growth and a congregation that reflects the local community. He states that the vicar spearheaded the events and functions of the church. It was much more than a few quiz nights. She was very organised, very detailed with the outreach that we would do in the local community. I remember one particular Sunday, there was a comment by Senior Bishop that he'd been to many churches, but All Saints struck him for openness, friendly and a happy atmosphere. The PCC is very diverse. The PCC would visit the local community, prepare food for those who needed it, the elderly and the disabled. It created a cycle where people would see us as a PCC in the community. They would see the human side of the mission. Having black PCC members meant ethnic minorities, members of the community who might not join, would feel safe and welcome to. This is how our church grew. He refers to the church having built up trust with local community, particularly with the Shrublands estate, over many years through our community work, knowledge and trust. He concludes that losing All Saints would affect the black community particularly harshly. It would be devastating. The spiritual home of the community would be gone in the vicinity. There isn't a church within the same history or motivation in the area at all. To summarise, the evidence presented illustrates the profound and disproportionate impact the scheme to close All Saints Parish would have on the black and brown community. Witness statements and statistics reveal that the congregation of All Saints is predominantly black and brown, reflecting the demographics of the area it serves. Testimonies highlight the integral role the church plays, providing spiritual support, community outreach and empowerment to black and brown members. Closure of the parish threatens to uproot this vibrant community, erasing decades of progress and support networks built within the black and brown community. Now, my learned friends attempt to rebut this obvious conclusion in three ways. Firstly, they contend that the draft scheme must be evaluated in its entirety, not solely based on the impact on All Saints. However, what remains glaringly absent from their rebuttal is any evidence refuting our assertion, supported by evidence, of the scheme's disproportionate impact on black and brown people in the black and brown community. Despite the seriousness and gravity of our claims, which I say is supported by substantial evidence, the commissioners haven't, for example, filed any evidence from the incumbents, PCCs or parishioners of the other two affected parishes, which that would support the view that the scheme will overall improve the ministry for black and brown people, or that it would offset the prejudice to black and brown people that our evidence clearly demonstrates. If the commissioners wanted to make their case and challenge our position, it's incumbent on them to substantiate their arguments with evidence. Regrettably, they haven't done so. Secondly, the commissioners assert that members of one racial group have no justified grievance if they are ministered by a person of a different racial group. Well, forgive me, but while we acknowledge that the clergy of any race can effectively minister to parishioners regardless of racial background, our argument doesn't hinge on an entitlement to be ministered by somebody of the same race. That's not what we're saying. That's not the test. Rather, our contention revolves around the unique and successful mission developed by All Saints, spearheaded by its current incumbent and the PCC, specifically tailored to the local black and brown community. This loss of a specialised mission would undoubtedly prejudice the existing congregation and community, which, as demonstrated by the evidence that I've taken you through, is disproportionately composed of individuals from black and brown backgrounds. It's imperative to recognise that this submission is not a blanket assertion that the replacement of a black incumbent with a white incumbent always results in prejudice against the black and brown practitioners. The outcome heavily depends on the individual qualities of the incumbent and the context of the parish. That is a fact-specific submission which is rooted in the evidence about the particular circumstances of this parish. Therefore, this appeal necessitates a meticulous examination of the parish's real-world circumstances, which is why it took some time to take you through those witness statements, and the impact of the proposed changes within this specific context. No one is saying, as a global proposition, that the replacement of a black incumbent with a white incumbent will also always have a prejudicial effect. That is not my submission. The respondents further contend that All Saints cannot be deemed to be inherently black and brown led, citing the Reverend Clark's eventual retirement and potential for the PCC members' re-election. However, I delve deeper into this point when I address ground 3 in a moment, and I'll come to that. Nonetheless, it's crucial to underscore that the Cheeseman case, that's at page 1827, that's Cheeseman 1827, establishes that personal qualities of the current incumbent hold substantial relevance in appeals of this nature. Such appeals do not assess the scheme based on hypothetical scenarios involving future incumbents or PCC compositions. Rather, they scrutinise the scheme's real-world operation in the present context. And I say it's imperative to recognise that the current incumbent and the PCC have cultivated a specialised mission tailored to the black and brown community, which forms an integral part of All Saints' identity and function. Therefore, any assessment must consider the scheme's impact within the framework of the existing circumstances. Now, the Commissioner's third argument fails to diminish the relevance of considering the characteristics of the existing incumbent and PCC members when evaluating the potential impact of the scheme on BAME individuals. Now we don't need to disregard the characteristics of the existing incumbent and members when considering whether the scheme would have a disproportionate impact, prejudicial effect. It's pivotal to understand that the focus isn't solely on whether alternative parishes, that's St John's or St George's, possess the capacity to minister to black and brown individuals, or whether there would be a near net reduction in ministerial provision. Rather, I say the crux of the matter lies in determining whether the loss of All Saints' current and distinctive effective mission would be a disproportionate disadvantage to black and brown individuals compared to their white counterparts. And I say the evidence unequivocally indicates that disproportionate impact. That would also deal with the Commissioner's third argument, because we say it plainly would. With that established, if you accept those submissions, the burden would then shift to the Commissioners to substantiate an objective and reasonable justification for the indirect discrimination. Given that the discrimination, we say, is rooted in race, this imposes a substantial burden on them, necessitating the demonstration of weighty reasons. It's imperative to underscore that any justification proffered must withstand rigorous scrutiny and meet the exacting standards set forth by law. This is essentially two limbs, and one is the Commissioner's. Sorry, let me repeat that. There are essentially two limbs of claim justification in this case. Number one, the Commissioner's allegation is that there's a low level of parish activity. We do not accept that. The appellants have put forward a substantial amount of evidence about the work that All Saints is engaging in. And can I take your lordships to the P100 form, which you'll find at page 506 to 507. And that sets out the many activities, including music, summer workshops, school choir competitions, legal clinics, Bible studies, working with Shrublands Estate Trust, the Shrublands Food Bank, the Railway Safety Scheme, the First Aid and CPR training, summer fairs, Christmas bazaars. Much of this, my lords, was reiterated by Reverend Clark at the hearing, and she also highlighted the parish's sensory garden for children with special educational needs. You'll see that at paragraph 24 of the Statement of Reasons, which you'll find at page 20 in the bundle. There have been legal clinics at the church, which is corroborated by a letter from Dave Nieter to the Bishop of Southwark. You'll find that at page 260. And in the supplemental submissions by Andrea Holding, which you'll find at page 570. And I've already highlighted the evidence of Mr. Dubé and Mr. Williams about the outreach of the church to the Shrublands estate. Now, despite the weight of evidence presented in support of our contention, the Commissioners, by contrast, have failed to provide any substantive rebuttal. They've not presented primary evidence from the clergy or laity within the local community to counter the comprehensive account of All Saints' activities and its profound impact on the black and brown community. By neglecting to address this detailed narrative with substantive evidence of their own, the Commissioners have left critical questions unanswered and failed to adequately engage with the realities of the situation. Now, the Commissioners did rely on a witness statement by Rosemary Mallett, and you'll find that
Mr. Thomas, I have to warn you that you're now eating into your reply time, so you have to be aware of that.
I'm aware of that.
Thank you.
Okay, thank you, my Lord, for drawing that to my attention. The commissioners did rely on the witness statement of Rosemary Mallet. You'll find that in the bundle at page 100. She was concerned that regular services were not taking place. You see that paragraph 40 on page 100. Paragraph 40, 100. I previously addressed this issue in my submissions on Clark 2. Clark 2 is the supplementary witness bundle, and your lords were going to decide whether or not you're going to admit that witness statement, but there is the rebuttal there. In my submission, there's no reason to doubt the accuracy of the service registers exhibited in Clark 1, that's the first Clark witness statement, which clearly regularly shows that regular services are taking place. Even if Reverend Clark had been following the wrong practice on how she records attendances, as alleged in Thomas 1, that's the first Thomas statement, that does not affect the accuracy of the records. The records show that attendance is variable. There were 35 communicants on Easter Sunday in 2023. That's page 1098. 29 communicants at Christmas Midnight Eucharist at page 1093. There was the Century Garden opening in August 21. That's page 1090. My Lord, I'm going to skip over this, but if your Lords look at pages 1090 to 1098. So 1090 to 1098 as to the parish's activities. In essence, we say that the All Saints represents a vibrant parish characterised by rich spiritual community life, where Reverend Clark enjoys widespread administration and appreciation by a number of parishioners. And the evidence presents a vivid picture of deep connections forged in the local community and in the local minority ethnic community. Now, the commissioners place a significant amount of emphasis on the finances as the cornerstone of their argument. And while I acknowledge the importance of financial considerations, particularly in the management of parish affairs, I contend that mere financial concerns fall short of meeting the threshold to justify indirect discrimination as alleged in this case. Despite the assertions made by the commissioners regarding the financial state of the parish relative to others within the diocese, they fail to provide any compelling comparative statistical evidence to substantiate their claims. In the absence of a robust empirical data supporting their position, it's untenable to hinge such weighty decisions solely on financial grounds. In other words, I say that the indirect discrimination that we allege, even if the parish has financial difficulties, that wouldn't justify wouldn't be a sufficiently objective and justifiable reason for the indirect discrimination.
I don't wish to take you out of your line when time is running out, but when you talk about comparative statistical evidence, what were you envisaging should have been produced?
So, for instance, we know that there are 3 other churches in the area. I've made reference to them. It would have, if the commissioners are saying that it wouldn't have impacted the black and brown community within the area, they could have said St George's has this black population, this Asian population, St George's does this for the black and brown community, and therefore the loss of Spring Park would not have does not impact because you've got what All Saints is providing, provided by the other parishes, but they haven't put forward that evidence.
So you're thinking of the makeup of the congregation rather than the ethnic makeup of the parish itself.
We have
the latter in the statement of facts and issues.
Yes.
Part of the difficulty is it's very unclear what comparison you're making because it seems to keep shifting. Sometimes it's comparison within the congregation, sometimes within the parish, sometimes between one parish and the others, sometimes between black people in one parish and black people in the others. Sometimes it seems to be with the black people in this parish and white people in the others. And unless one focuses on the which group is being treated more favourably than the other, it's impossible to know what is meant to be justified.
Well, firstly, what we do know is that this is a predominantly black church. That predominantly black church, it's proposed that it be closed. That will have, I say, when you compare it to the other church, that will have a disproportionate impact on black people, because a church that they go to, in comparison to the other two churches, has a disproportionate impact on the black people of All Saints. So that's one clear example, I would say. There's been no statistical evidence to challenge that. It would have been easy for the commissioners to say, no, there isn't a disproportionate impact on black people in the area, because what is being taken away from All Saints is equally provided by simply showing there's a large number of black people in the other two parishes.
I think we do have somewhere figures of ethnic backgrounds of those attending the other churches. But I mean, I don't think they show the same large majority that is the case for All Saints of black and brown people attending.
I think it's paragraph 15 of the Statement of Facts and Issues that gives the basic detail.
This is paragraph 15, and sorry for rising, but in the first sentence of paragraph 17, we say, of course, that proportionately we accept greater proportion for All Saints, but by reference to absolute numbers, All Saints is the same or amongst the worst, and All Saints is, of course, a more populous parish. And I'll be expanding on those submissions in due course.
Yes, thank you.
My Lord, I note that time is really short, and I'm running over time. I want to deal with ground 2 very quickly and then come to ground 3.
You can always fall back on your written case, because you don't have to articulate everything orally. We will have regard to what you have written as well as to what you say.
Well, my Lords, I'm going to fall back on my written case in relation to ground 2. I want to come to ground 3, if I may. Please. And if I'm wrong on grounds 1 and 2, and I accept that grounds 1 and 2 very much depend on whether or not the commissioners are public authority. So assuming that you find against me on grounds 1 and 2 that the commissioners are public authority, I still say that the matters that the DMPC were required to consider in making the proposals are set out in section 3 of the 2011 measure. That's at page 1471, and the DMPC were required to have regard to the worship, mission and community as central to the life and work of the Church of England. That's section 3.1. Now, what we say that the Cheeseman case, which is at 1827, that's 1827, was decided under the predecessor measure. Whether the scheme was made better provision for the cure of souls, see 1832, between letters E to F. So 1832, letters E to F. This is of course a merits appeal. That said, I accept that the authorities indicate that there's deference to the view of the church authorities. However, even if Article 14 of the Convention doesn't apply, nor the public sector equality duty, underground too. The spirit of those duties as regards race is of primary relevance to the cure of souls, and therefore to a merits appeal. And I say that for the following reasons. I want your lordships to go to page 6808, which is the lament from lament to action. This is a landmark report from the Archbishop's Anti-Racism Task Force.
Could you give me the page number again?
608 in the bundle.
Yes, I have.
And although I accept this document is not a source of law, as it happens, it was endorsed 2 days ago before the General Synod unanimously. And in my submission, it's immensely important to understand the relationship between anti-racism and the Anglican mission in the 21st century. And there's an important quote at page 615. Addressing systemic and institutional racism and racial sin in the Church is not a theological addendum. It's a missional imperative of the Church of England as set out in the Anglican Commune fourth mark of mission, to transform unjust structures of society, to restore the equal dignity of each person as holding the image of God. The Christian narrative of reconciliation offers us an invitation to confess the sin of racism and to acknowledge our past and present complicity in various forms of ethnic discrimination and racial prejudice, so that we may truthfully and honestly work together and build a kingdom of God here and now. Now, at page 622, the report quotes from the 1985 landmark report, Faith in the City, saying there's a great deal of evidence that black people felt themselves unwelcomed in British churches, just as in many other parts of English society. And that report at 662 makes an important point about culture. Quote, 662, there's a quote. One of the barriers to the inclusion of continued participation in the Church of England from those from the UK minority, ethnic and GMH and other backgrounds has been the challenge of cultural assimilation into the Church, where there's perceived to be little or no room for cultural expression outside of the predominant culture, which is predominantly white and middle class. I'd like to underscore two pivotal points here. First, in the realm of spiritual guidance, embracing the anti-racist ethos is not merely an optional addendum, but an indispensable mandate. It's intrinsic aspect of the mission as articulated in the report as a missional imperative. And this means, my lords, that any consideration of its mission must include a robust interrogation on how it confronts and dismantles racial injustice. Secondly, a colourblind, one-size-fits-all approach to ministry is fundamentally flawed and must be unequivocally rejected, as such an approach fails to acknowledge the systemic inequities embedded in society and the Church's own history of perpetuating racism. And by embracing a colourblind perspective, it inadvertently overlooks the unique experiences and needs of individuals from racial backgrounds. It's imperative that the Church recognises and addresses these disparities head-on, tailoring its ministry to specific needs of each community it serves. In essence, to truly fulfil its mission, the Church must reject a homogeneous approach to ministry. Now, my learned friends think our case has changed. It's not. It remains the same, that All Saints offers an irreplaceable mission to black and brown people in the Spring Park Shirley area. That's the crux of our case. My learned friends rely on the fact that there's no guarantee that the ethnic makeup of the incumbent would remain the same. And I draw your lordships to the Cheeseman case, which I've already touched upon. But can I just ask you to look at the quote at page 1835 in Cheeseman, which begins at to exclude all considerations of the contribution down to argument cannot be sustained. So to exclude all considerations down to arguments cannot be sustained. That's on page 1835 of Cheeseman.
So which marginal letter do we start at?
I'm sorry, my lord. In my notes, I omitted to do that.
I think it's a G.
G. Thank you.
G.
We say that nearly there. You cannot ignore the personal qualities of the incumbent when determining the necessity of a pastoral scheme. Such an approach would be artificial and undermine the legislative intent, and I get that from Cheeseman. Next, my learned friends say that the board has already construed the 1968 measure as being concerned with the pastoral care of all parishioners, and rather than any particular demographic. And they cite the Williams, that you'll find Williams at 3243, and they rely on a passage in Williams from 3246 to 3247. But we say Williams has got nothing to do with race or racism. It does not say that indirect discrimination is relevant to the cure of souls. It is, of course, right that the effect of the scheme on all affected parishioners must be considered, but that does not mean that indirect discrimination is to be ignored when considering a pastoral scheme appeal, and there is no authority that it should be. So in my submission, it's deeply unattractive for the commissioners to submit that when making decisions about the cure of souls in the exercise of its functions on the ecclesiastical law, they are to be held to a lower standard of anti-racism than that to which the law upholds public authority. So this is in the event that you find that the commissioners are not the public authority. I say it doesn't make a difference. They should be held to the same standards as public authorities, which require that indirect discrimination should be treated seriously, just as public authorities are required to consider the harmful impact of indirect discrimination. The church should be as well. I've already taken your lordships to the evidence in terms of impact. I'm not going to repeat that. My learned friends, with considerable fairness, have drawn your lordships' attention to the case of PCC of Holy Trinity, Birkenhead, and the church commissioners. And you'll find that in page 2246. And that makes the following important observation at 2248. As regards 2248, that's the quote. As regards finances, although these might appear to be precarious, their lordships do not attach great importance to that. There are poor parishes in every diocese, and they have to be supported by the diocese if they require for church people of their district. The question of whether Holy Trinity is so required, if the petitioners are right in saying that it would, then poverty is irrelevant. That said, my learned friends rely on what is said in Williams, but the context of that observation is important. The parish in this case did not have its own vicar. It was under the care of the vicar of another parish as a priest in charge. And their lordships went on to say in Williams that the parish received inadequate pastoral care in recent years. That's important because there's no suggestion in this case that the Reverend Clark has provided inadequate pastoral care. What's been said in this case is solely about the finances. And in short, while I do not dispute that finances are a relevant consideration for your lordships, it should not be given overwhelming weight next to the evidence that your lordships have seen about the irreplaceable mission of this parish to the black and brown community. This is a case where there's cogent evidence of where we say the commissioners just haven't considered this properly. So, I conclude by saying this. I say, collectively, grounds 1, 2 and 3 present compelling reasons why this appeal should be allowed. I won't repeat the grounds. Ground 2 you'll read on paper. Ground 3 underscores the significance of considering, firstly, the personal characteristics of the incumbent in evaluating the scheme. We say the arguments elucidated show the vital role that Reverend Clark plays in serving the black and brown community and the unique mission of All Saints in catering for their pastoral needs. If you disregard these facts, as we say the Commissioner's decision appears to have been fairly myopic, that fails to appreciate the nuanced dynamics at play. Furthermore, the potential for alternative measures such as collaborative redevelopment efforts as suggests that the scheme's necessity is questionable, and we say there should have been more engagement between before the scheme was made with the church. In the light of these deficiencies, we say it's evident that there have been various breaches and this appeal should be allowed. Unless I can assist your lordships any further, and I do apologise for going over my time, those are my submissions.
Yes. You have confined your reply time to 10 minutes.
I understand that.
In fact, the way you were presenting the case, you were addressing in advance some of the points that will be made against you, so that you may not be discriminated. You may not be prejudiced by that. Thank you very much, Mr. Thomas. Ms. Wakefield.
My Lords, I should start by saying that, of course, the Commissioners very much acknowledge that racism has been an important part of the lived experience of Mrs. Clark and the members of the PCC at ASSP as individuals in the parish and, of course, in other contexts. Now, that sentiment is expressed in terms in paragraph 135 of the full statement of reasons for our decision, which is at page 34 of the bundle, but of course it remains very important. And of course, more broadly, the Church recognises the lament to which my learned friend took you earlier on and the problems of racism more generally at large. Against that context, it's obviously unfortunate that at times in my submissions today I'm going to have to make submissions that are difficult to make, perhaps, and difficult to hear. On the other side, and I apologise in advance. I'm going to try and make those points as courteously and as kindly as I possibly can. But when we get to justification in particular, as well as differential impact, I'm afraid I am going to have to make the points which I need to make. And I apologise in advance for the necessity of doing so. So against that backdrop, or with that opening position, I'm going to turn to public authority, first of all. Issue 1, under Issue 5, did the Commissioners act as a public authority? That, of course, turns on the proper meaning of Section 6 of the Human Rights Act and its application in this case. We have Section 6 in the bundle, page 1225, and we have, of course, the very considerable benefit of Aston Cantlow. That authority is of diminished importance in my learned friend's case and in his submissions yesterday. And of course, he seeks to confine it to its particular facts in his written case, namely that it concerned a PCC and that it concerned a particular type of liability. In my submission, that rather underplays its relevance. In my submission, it's of very direct relevance. I'm not going to take you to Aston Cantlow. If I had days and days to make my submissions in a leisurely manner, I'd doubtless take you through it paragraph by paragraph, but I'm going to seek to elicit 6 core propositions. First of all, the purpose of Section 6 is that, and here I quote from Lord Nichols at paragraph 15, those bodies for whose acts the state is answerable before the European Court of Human Rights shall in future be subject to a domestic law obligation not to act incompatibly with convention rights. So that means that the case law of the Strasbourg Court on the question is highly relevant and forced to be taken into account, and that Section 6 should be construed to capture, and to capture only, those entities for which the state would be held responsible in Strasbourg. The Strasbourg authorities, which I'll come back to, in general speak against religious entities being viewed as governmental, even if they are the established church, with close connections to the state, and even if they are otherwise viewed as public law bodies. The religious and spiritual nature of the mission is plainly a dominant factor in that analysis. Secondly, public authority is dealing with functions which are governmental in the broad sense of the term, and the reference in Section 6, sub 5 of the Human Rights Act to private acts is intended to distinguish governmental from private acts. Now, that reflects the core opposition in the Convention between non-governmental organisations, which of course have standing for Article 34 purposes, and governmental organisations which do not. So that's where we get the word governmental from. And of course, in holy monasteries, we get there in due course, we have a governmental organisation established for public administration purposes. We also have that language coming through as well, public administration purposes. Thirdly, the identification of core public authorities, such as governmental departments, local authorities, the police and armed forces, that's likely to be relatively straightforward, and it's highly material in considering whether a body is a core public authority, that a core public authority cannot be a victim, so cannot have convention rights. It would be, as noted by Lord Nichols, an extraordinary conclusion in the context of the entities of the Church, taking some extreme and hypothetical examples, for a body to be a core authority. For example, religious property could be expropriated by the state without any complaint under Article 1, Protocol 1. Or as my Lord Sales put it in argument yesterday, the state could instruct the body about how to further the mission of the Church or how to undertake religious tasks without any complaint under Article 9 raised by the Church as against the state. Fourthly, there is no single test of universal application which determines whether a function is governmental or public for this purpose. Factors to be taken into account are set out in paragraph 12 of Lord Nichols' speech, and they include the extent to which, in carrying out the relevant function, the body is publicly funded, exercising statutory powers, and taking the place of central government or local authorities providing a public service. And as Lord Richards rightly observed in argument yesterday, if one is dealing with a potential hybrid authority, one need not, or one should not consider all of its functions, but instead simply ask whether the particular function at issue is public or private. Fifthly, the Church of England has historically discharged an important and influential role in national life. The King is its supreme governor, and it is established in the classic sense that its rules form part of the law of the land, and it does maintain special links with central government. But it remains essentially a religious organisation, and it acts, again in the language of Aston Cantlow, in the sectional, not in the public interest. The mission of the Church is a religious one, not a governmental one. And while the Church may perform some public functions, one of the examples given is church schools, that does not and cannot make the Church as a whole or any of its entities or emanations governmental or religious organisations. Church bodies engage in self-government and promotion of their own affairs, and they are far removed from the type of body whose acts engage the responsibility of the state under the European Convention. The Church does not exercise delegated state power, and the state would not take over the Church's functions if the Church ceased to perform them. Sixthly, and importantly, the body in Aston Cantlow, of course, the PCC, was incorporated by church measure, which we know is a form of legislation, and exercised special powers under legislation, in that case under an Act of Parliament, not a church measure. That was, of course, insufficient to render the relevant function a governmental one. Were the contrary to be the case, at least so far as establishment is concerned, that would mean that many entities in the Church, a Church established by law, would be exercising a public function, because those establishing measures in the established Church take the form of a measure having the force and effect of an Act of Parliament. They're simply the means by which the established Church organises its own affairs. So those are the 6 propositions which I would take from Aston Cantlow.
Can I just ask you this?
Of course.
Church measures, they're passed by synod, as I understand it.
Yeah.
They have a sort of legal force by dint of primary legislation that you refer to, but do they themselves go through any parliamentary process, the church measures?
They do, I think.
Well, they're passed by, well, at some point, let me know.
The positive resolution of the House.
Of each house?
Of each house. Each
Thank
house
you.
in the measure.
Yep.
So Lord Nichols' factors in Aston Cantlow were, of course, endorsed by the House of Lords in YL, and we have that at page 3264 in the bundle. Of course, your Lordships will be familiar with this case, and of course my Lord Sales, I think, appeared for the Secretary of State in this case, which concerned an elderly woman in a care home where the fees were largely paid by the council. The company which provided the care home sought to terminate the contract for her care, move her out of the home, and in a challenge to that decision, one issue was whether the company was a hybrid public authority, and the outcome was the 3-2 decision that the company was not a public authority, with Lord Bingham and Baroness Hale dissenting and Lord Scott, Mance and Newberg were in the majority. So if I briefly go to Lord Mance's speech, or at least the most relevant sections, go to 3294. And here we have the heading at the top of the page, Guidance to the Interpretation of Section 6(3)(b). Paragraph 87, His Lordship refers to Aston Cantlow and to that core rationale that Section 6 intends to reflect state responsibility in Strasbourg. He notes that this was addressed by Lord Nichols, Lord Rogers, and endorsed by Lords Hobhouse and Scott. Paragraph 88, over the page, says that rationale applies as much to hybrid authorities as it does to core public authorities. And then in paragraph 91, His Lordship endorses governmental as the test, and my Lord Sales's proposed approach of a factor-based approach, as set out in paragraph 12 of Lord Nichols's judgment in Aston Cantlow. So, is the body publicly funded, exercising statutory powers, taking the place of central government or local authorities, providing a public service? Then in paragraph 92, on page 3296, in light of the rationale of Section 6, it's logical to start by considering whether Strasbourg case law offers any clear guidance on the scope of state responsibility in the present field. So that's where His Lordship says we should start our analysis. And then the final paragraph in YL is paragraph 101, in which His Lordship says the mere possession of special powers conferred by Parliament does not by itself mean that a person has functions of a public nature. Such powers may have been conferred for private, religious, or purely commercial purposes.
Sorry, can you just give me that reference again?
Of course, it's paragraph 101 on page 3300.
Right. Yes, thank you.
So if I turn to the Strasbourg authorities, and we start with holy monasteries, to which the board was taken yesterday, that's at page 3603. And of course this concerned whether the monasteries were part of the Greek state and therefore disabled from bringing a complaint in Strasbourg. If we start with paragraphs 10 to 11, which we looked at yesterday with my learned friend, that's page 3610, and we see the property of the monasteries historically vested in that public law entity, the ODEP, whose board included a judge of the Supreme Administrative Court, head of Treasury, and a representative of the central bank supervised by a government ministry. And we see ODEP's original functions at paragraphs 11 to 12. Just 11 perhaps. And then in paragraphs 12 to 15, we have the legal status of the monasteries and the church set out here. And it is worth perhaps reading through these paragraphs to identify quite how close the links were between the monasteries and the church. We see that the state contributes to their funding. Looking for the correct paragraph for that reference. bottom of 14, I'm told. There we have financing. The law provides the state is to contribute to the church's expenses. We see managerial acts as subject to the state's financial supervision. As to staffing, the provisions governing public servants, which apply by analogy to the staff of the church, public law entities. Over the page 3612, in the second paragraph down, the holy monasteries are public law entities. They may be founded, merged, or dissolved by means of a presidential decree adopted on a proposal by the Minister for Education and Religious Affairs after consultation with the religious bodies. So very, very close links there between the holy monasteries and the state. Then we go to paragraph 24, which sets out the legislation, which I think we considered very quickly yesterday, which changed the constitution of the ODEP and then provided for the state to become the legal owner of all monastery property. And we have the relevant provisions in that piece of legislation in paragraph 25. Most notably, on page 3616, this is in section 2, sub 2 of that piece of legislation, and my Lord Sales referred to this yesterday, I think, that within 6 months of the entry into force of this law...
Sorry, where are you?
I'm at the top of page 3616.
Yes.
And I'm in little paragraph starting with the 2.
Paragraph 2.
2, thank you.
2 or 3?
It's 2.
2.
Thank you.
Within 6 months of the entry into force of this law, the ODEP may, by contract to be signed with the Greek state, as the representative of the holy monasteries, then we see transfer to the state the ownership of the monastery's immovable property. And then we see lower down the page under section 3, next to big A, or 1, so if we start with 1 under section 3, if nothing has taken place at the end of the 6-month period provided for, then A, immovable property in use or possession of the holy monastery should be deemed to be the property of the Greek state. So essentially, the ODEP is a kind of transferal mechanism of the properties from the holy monasteries to the Greek state, and the Greek state is referred to separately in that legislation. The reason I'm dealing with this so compendiously, I should say, is it's not addressed in my written case, and of course, yesterday my learned friend placed reliance on the position of ODEP. In paragraph 30, on page 3618, you see the chairman and other members of the ODEP were appointed by the Minister for Education and Religious Affairs. And then in paragraph 35, which is on page 3623, the ODEP was destined to be wound up once the operations had been concluded. So it just had that mechanistic transfer. Now, in paragraph 90 of the Commission's decision, which is on page 3634, paragraph 90, the Commission does find that ODEP is the state institution ODEP. The court never considers the status of the ODEP at all. And then in paragraphs 48 and 49 of the court's judgment, which is of course the famous paragraphs for the question of public authority, and that's on page 3642 and 3643, we have the court's determination of the critical question of the status of the holy monasteries themselves, those bodies that can be created or dissolved by state decree, funded by the state, public bodies under the state law, whose employees are civil servants, and so on. And we're very familiar with these paragraphs. They're set out repeatedly in Aston Cantlow and elsewhere. But of course, the critical importance is the objectives of the monasteries, which means that they cannot be classed with governmental organisations established for public administration purposes, despite how close those links are with the state. The second Strasbourg case, which their lordships in Aston Cantlow all considered, and which my learned friend referred to yesterday, is Houghtonamy. And that's at page 3600 in the bundle. This is an admissibility decision in which the Commission applied holy monasteries.
Sorry, could I have the page number again?
3,600.
Thank you.
And we see on the first page in paragraph 1 that the applicants complained that the Church of Sweden had prohibited the applicant parish from using the Finnish liturgy. Although both church and parish are corporations of public law, they cannot be considered to have been exercising governmental powers, and so are non-governmental organisations.
So are you reading now? Oh, you're in paragraph. Oh, I see. Yes, I see. Yes,
sorry.
yes.
A mixture of reading my notes and reading the
Well,
case,
it's
so-
yes. It's. I mean, I'm looking at this for the first time, so it's helpful to know where you are.
Of course. That means that the parish can be a victim. However, we see at the top of page 3601, it's the second paragraph there, Manuel Richards. The Commission therefore considers the applicant parish can claim to be a victim. But then we see in the next paragraph, the Commission has just found that for the purpose of, at that time, the relevant standing article of the Convention, the Church of Sweden and its member parishes are to be regarded as non-governmental organisations. It follows that the respondent state cannot be held responsible for the alleged violation of the applicant's freedom of religion resulting from the decision of the Church Assembly. So both parish and big church sitting above the parish, they're both non-governmental organisations, despite the fact that they're public law entities. And in the next paragraph, we have the reasoning that the applicant parish forms an integral part of the Church of Sweden. As such, the parish is obliged to comply with the Church Assembly's decisions concerning inter alia the manner in which religious services should be conducted.
I'm so sorry, where are you reading from now?
That's the next paragraph down. So if we're on page 3601, and hopefully there are no paragraph
It's
numbers.
the third paragraph.
The third one down.
yes, got it.
It's the third one down. And in the third paragraph and the fourth paragraph, my lords, one sees the point which I referred to yesterday in the Article 9 context, that when the Commission, as part of admissibility, is considering public authority in the context of a religious organisation, it tends to say, well, you're not a public authority, but also plainly adherents to your organisation, such as a parish, a constituent member or a clergy person, cannot exercise an Article 9 right vis-à-vis the governing entities of that same church. Because we see in that fourth paragraph down, the way that that right is exercised is by entering the church, joining in the first place, or leaving if you no longer agree with it. So in our case, in paragraph 53 sub 3, we also address the positions of the Lutheran and the Catholic churches in Germany, because they were also mentioned in Aston Kant Law, and we set out the Strasbourg case law, which subsequently has said that they are not public authorities, despite their very close enmeshment with the German state. My learned friend relies on some additional Strasbourg authorities, X in Denmark, Knudsen, and an Icelandic case, which again I address in my written case, para 56, that's at page 1049. And again, they dictate no different results at all. This very standard reasoning is applied, in particular in X and Denmark. I would like to turn to Fernandez-Martinez, if I can quickly, which is at page 3543. This is a Grand Chamber decision. (3,543). And we see in the head note at paragraph 1, the applicant was a teacher of the Catholic religion and ethics in a state-run school. His employment was terminated as a consequence of the decision of the relevant diocese, and the court's assessment starts at paragraph 102, which is on page 3570. Now, the paragraphs on which my learned friend relies in his written case And I don't think he took you to it yesterday, but I'll address it nevertheless. It's paragraph 115.
Paragraph 1.
115, my lord.
Okay.
At page 3573. And in that paragraph, the second sentence, the court accepts that even though it was not a public authority which had actually taken the non-renewal decision, it sufficed in the present case for such an authority to intervene at a later stage for the decision to be regarded as an act of a public authority. So what happened in this case, essentially, is that the diocese gave a view as to whether the teacher was any longer an appropriate teacher of Catholicism. That view went to the state, and the state sacked the teacher from the state-run school. Now, this is the case that is the best case that my learned friend has, and it is plainly insufficient for his purposes, because there was the intervention of the state, and of course the Grand Chamber expressly refers to the fact that a public authority, the state, then intervened. While we're here, could I also ask the board, please, to read paragraphs 127 to 129. This is on page 3576. And this is in the scope of the internal autonomy and the Article 9 tricky point that we have in this case. So it was said by my learned friend yesterday, well, sure, absolutely, there's no internal right of dissent, but that only really applies to particular aspects of theology or doctrine. And what we see in paragraph 127 in particular, and we see in the last sentence, the organisational life of the community is protected by Article 9. And we see that running through these paragraphs, that an important feature of the case law on the interaction between religious organisations and the Convention in general is this protection against state intervention and on all things internal to the religion. And I do say that it would not be within the ambit of Article 9 for a priest to object to an internal organisational change in his or her parish. And your lordships will immediately appreciate that that is very close to the facts of this case. This case is more complicated because of the purported representative function in relation to worshippers and residents more broadly in the parish. So it's not as straightforward priest objects to dissolution of a benefice case, and the Reverend Von Clark does not bring it on her own account. She's expressed she does not bring it on her own account. But I do say that this internal opposition aspect of the ambit of Article 9 does apply to internal organisation. And I also say necessarily that's the case because internal organisation relates to mission. We don't organise the parishes for any reason other than the fundamental reason of the best delivery of the mission of the Church of England. And you see that, of course, in section 1 of the measure in our case. So to draw Strasbourg authorities together, there's no case which supports Mr. Thomas's position. None of the Strasbourg cases indicate the state would be answerable for the actions of a church in this sort of situation. And of course, you have my submission that the critical question for Section 6 is, what would Strasbourg do? In my learned friend's written case, recognising his position, he says, well, it's arguable they might accept it, but of course we know arguability isn't the right test for Strasbourg. We know Ellen Kane, we know the established approach, that we look at the cases we've got, we see the principles we can elicit from those cases, and we see whether with confidence we can say that they would be developed, and we absolutely couldn't in this context. So if I turn now to submissions on core public authority and then on hybrid, my learned friend's primary argument was that the commissioners are a core public authority, and he made that in paragraph 41 of his written case, and he made it briefly orally yesterday before pivoting to focus on hybrid. So I say that that submission simply cannot be maintained realistically in the face of Aston Cantlow. In that judgment, their lordships noted the very profound consequences of the status of being a core public authority, namely that in all aspects of that entity's functions and activities, they will possess no convention rights. And I've already referred to paragraph 15 of my Lord Nichols's judgment, in which he said that would be extraordinary. I would also refer your lordships, I'm sure you have this in mind already, to section 13 of the Human Rights Act, which expressly refers to the particular protection of religious organisations, and which again indicates, and my Lord Nichols made this point in Aston Cantlow, that it would be very surprising if religious organisations were not to possess convention rights ever, because they're core public authorities. And you have my submissions that it would mean that, unlike the holy monasteries in Greece, property could be expropriated, no convention right. My learned friend relied on a number of matters in particular. So the first one, his main one in a sense, was that the commissioners administer property. And he says that that's something kind of public law, of a public law nature. In itself, I think that's probably wrong anyway. And it's not engaged in the provision of ministry. So several answers to that. Obviously, administration of property, not inherently governmental. Obviously, the PCC in Aston Cantlow was enforcing a property right. But also, of course, critically, the commissions do not administer property for its own sake alone. They do so for a number of purposes, but most critically to further the cure of souls. And I referred yesterday to the case of Harries and the Church Commissioners, which I won't go to, but at page 2074, you'll have the judgment of Sir Donald Nichols, the Vice-Chancellor, in which he says the Commissioner's twin objects when administering property are provision of financial assistance and housing for the lower clergy, and the making of additional financial provision for the cure of souls in parishes. So those are the objects.
So could I have that page again?
Of course, page 2074, my lord. And on my note, I've written towards the end of the page, so that gives you an indication.
Yes, it's letter H, yes.
And of course, we have this critical function then of the cure of souls, the mission of the church, the cure of souls in parishes. And of course, that's particularly important in the present case, but we turn to that more when we're thinking about hybrid and not when we're thinking about core. My learned friend's attempted analogy with the ODEP in holy monasteries was with respect not convincing. There are manifold differences between the commissioners and the ODEP in any event. We're not supervised by a government department. We're not mandated by legislation to be a mechanism which transfers property from the church to the state. We're nothing like them. So really that goes nowhere at all. It was a false start, I think, to look at ODEP. The real comparator, of course, is holy monasteries themselves, but even they have considerably greater links with the state than we do. And they, of course, were not core public authorities. They were NGOs and so could bring a claim. Secondly, my learned friend relied on the fact that commissioners were established by measure and that they established powers under the measure. But the mere fact that the commissioners are established by measure and exercise functions under that legislation is true of many bodies in the church. You have that submission already. And it's a point made in Aston Cantlow, paragraphs 14, 58 to 59, 84, 86, 149. And in Aston Cantlow, of course, we have the observation, I think in paragraph 149, that one has different kinds of things created by statute.
So sorry, you went rather quickly over the references.
I'll
go slowly. 14, 58 to 59, 84, 86, and 149 to 152. And of course, these references are all in my written case as well. Then I think it's in the 149 to 152 that the observation is made that the PCC is not like the Equal Opportunities Commission. You know, one has things that are created by statute and then other things that are created by statute. The mere fact that one is created by statute doesn't make one a public authority exercising a governmental function for these purposes. Thirdly, my learned friend relied on the fact that some public office holders are ex officio members of the commissioners. That's right, but under the relevant measure, they have an extremely limited function. And if I could just take you to the measure, it's page 1348. So So on 1347, we have the title, the Church Commissioners Measure 1947. Then in section 3, over the page, 1348, the business of the commissioners, except the exercise of powers which, under this or any other measure or any enactment, are required to be exercised at a general meeting of the commissioners, shall be transacted in accordance with the provisions of this measure by a board of governors, hereafter referred to as the board. Then in section 5, which is on page 1350, in sub 1, the board shall consist of the commissioners mentioned in paragraph 1b of Schedule 1 to this measure. That takes us to page 1367, which is Schedule 1, Constitution of the Commissioners. And so we have in 1a, the office holders, First Lord of the Treasury, Lord President of the Council, and so on. And then we have under B, the following other persons, the archbishops, the Church of States Commissioners, the 4 bishops elected, and so on. And so the board, which transacts all the business of the commissioners, does not include those office holders. Those office holders have a very circumscribed role. And finally, my learned friend relied on the fact that the second Church Estates Commissioner is...
Sorry, just on that. What role do they have?
So if we go back to section 4, that's on page 1349. This is the general meeting, which section 3 referred to, my lord. And it's the annual report and accounts of the commissioners in little a of sub 2, and then in little d, considering and if thought fit, adopting the recommendations of the board as to the allocation of such monies as the board may report to be available. My understanding is they don't have any function in relation to this measure, though I appreciate for core purposes we're not focusing on this function.
Yes, thank you.
But one sees the delicate balance that's struck, in effect, and that it's an overstatement to say, oh, well, there are political office holders who form part of the commissioners. That's a mischaracterisation of how the commissioners work. Finally, then, my learned friend relied on the fact that the second Church Estates Commissioner is a Member of Parliament and answers questions in the House of Commons on behalf of the commissioners. That's true. He's appointed by the Crown, by convention from the Members of Parliament of the party with the majority in the House, but not a member of the government. And questions to him can concern anything, and by convention there's no limit. But my learned friend accepted yesterday, and this is entirely right, that of course the convention does not override any of the duties under this measure or any other duties, and it may be a slight overcharacterisation to say that that is democratic accountability in a conventional sense. These things, I think, my Lord Hodge said yesterday, they speak to the history of the Church and the Church's relationship with the state.
Yes, if you go back 400 years, there may have been a governmental role in the maintenance of true religion, as seen in the Anglican tradition. But as far as Strasbourg's concerned, the maintenance of the Christian faith, or and particularly in the form of the Anglican religion, is not a government function. That's your point.
That's my point, madam. That's my point. So I turn then to hybrid, if I may. So here, of course, we start by identifying the relevant function. In this case, function is the same as act, so there's no need to get sidetracked in that distinction, which we do in some cases, the distinction between public function and private act. It's the same thing here. And the function is the Commissioner's consideration of and decision to make a pastoral scheme under Part 3 of the measure. We've been to the measure several times now. I don't think we've been to the draft scheme yet. So if I could start by taking your lordships to it. That's at page 37. for page 37, we have the helpful box at the top, obviously not part of the scheme itself, but a helpful summary of the things that the draft scheme does. It dissolves the beneficent parish of All Saints Spring Park, divides the area up between the parishes of St George and St John Shirley. Parish church becomes a chapel of ease, and the parsonage house is transferred to the diocese to become diocesan glebe. And then we see in the draft scheme...
Just out of curiosity, if the parsonage becomes a diocesan glebe, what does that mean?
Goodness, that's a good question. I've probably got that somewhere in my notes, but it means essentially glebe land is land which was associated, I think, as I understand it, with a vicarage.
Yes, it was used to provide sustenance for the vicar.
Exactly, to supplement the income of the vicar, historically. Yes. And if it's diocesan glebe, it's that sort of land, but it belongs to the diocese.
Yes,
so they can use it to generate money for the diocese.
Yes, it becomes an economic asset for the diocese, is what I assume.
Yeah. It does, my lord. Yeah. Yes. So one sees, just working through the paragraphs, the first one, the most important, of course, is the benefice and parish of All Saints Spring Park in the Diocese of Southwark should be dissolved. Under 2, alteration of the areas of the parishes. So that which was formerly that parish should be split up between the 2. The church is no longer a parish church, and it reverts to being a chapel of ease. I do have compendious notes on how all these different things take effect. I'll take you to one via ease, but I'm not going to take you through everything. But in fact, we don't need to consider the different ways in which one becomes a chapel of ease, because one reverts to that, then would have to stop being a church in order to not exist anymore. Transfer of the parsonage house, we've just briefly discussed. And then under 5, this is the coming into operation of the scheme. So this provision doesn't dispossess the incumbent. The incumbent is automatically dispossessed by effect of the benefice no longer existing. And this instead is a protective measure which is obligatory under the regime established by the measure. And so it gives a delay, basically, of 6 months where an incumbent will be dispossessed under a scheme. Now, the only vires I think I should take you to, just because I'm conscious I haven't taken you to any of this yet, is section 31 of the measure, which is at page 1512. So section 31.1, page 1512, a pastoral scheme may provide for any of the following matters. And then B, the dissolution of existing benefices or parishes, and C, alteration of existing boundaries of parishes. And as I say, there are similar vires for the other aspects.
Presumably the measure contains somewhere power to transfer property without a conveyance or other assurance, which is goes against the general law at any rate. But I'm not asking you to point it out, but it must be there somewhere.
45.1b.
45.1b of the measure.
Of the measure, yeah, 1d, sorry, nearly.
So that's a church measure which overrides the general law.
Yeah.
Right.
So we have those substantive vires, if I can put it that way. We've also, of course, yesterday spent some time looking at the procedural structure of the measure. But of course, you'll have seen yesterday that it's not for the commissioners to initiate the process. That's not the function that we have. It's not for us, apropos of nothing, to design and propose a draft scheme. Instead, it comes from the diocese. It comes from the Diocesan Mission and Pastoral Committee. It then goes to the bishop of the diocese. And the commissioners then have their own important, but necessarily circumscribed function. So that consultative function, adhering to the procedural code set out in the measure. And of course asking themselves, do we believe that this is a draft scheme that has to be made? But nevertheless, by reference to that very considered earlier procedure from those closer to the ground in the diocese, because of course parish matters are, first instance, inherently matters for the diocese itself.
But do the commissioners not also have to look to make sure that the prior procedures have been properly carried out? My recollection is they do.
That's right, my lord, they do. Section 6, they have to satisfy themselves Section 6 being carried out. So my learned friend addresses hybrid public authority in paragraphs 42 to 43 of his written case, and in that, as he did yesterday, he uses the factors identified by Mr Justice Coulson, as he then was, in TH. So
those factors, the list is really just derived, isn't it, from what Lord Nichols said?
That's right, my lord.
It's sort of slightly dangerous to have a sort of checklist, isn't it?
Especially when His Lordship said we mustn't have a checklist.
Yeah.
But also I think that the last of those factors, which Mr Justice Coulson, as he then was set out, was what would Strasbourg think? And you already have my submissions that really should be the first and the encompassing factor. If Strasbourg would say, no, the state isn't responsible, that is dispositive of Section 6. So that's my core argument. So that shouldn't be a factor in any event. And I would also respectfully say that your lordship was entirely right yesterday to say factor 1 it is the main factor.
Factors 1 and 2.
Factors 1 and 2. So we have factors 1 and 2, critically important. Is this the sort of thing that the state does? Is it a public function in any normal sense of the word? Is it governmental? Does it have concern public administration? No, it absolutely doesn't. And then the Strasbourg, Coulson's factor 6, I say dominant factor, no Strasbourg case in support, none. And then all we have is the factors in the middle, if I can put it that way. And so we have democratic accountability. Well, you have my submissions on that.
Could you remind me of the page number of the list, please?
Of course, it's 3203.
Thank you so much.
Would it be helpful to turn the list up, my lord?
Well, if you're discussing it.
I didn't get the memories.
3203, 64.
3203. Exactly. So, A, is the body performing a task which a core public authority is under duty to perform and which has been delegated to it? No. And my learned friend conceded that. No. B, to what extent is the function of a governmental nature and or a part of public administration, so holy monasteries type test? It's not. So that's the answer, and again, my learned friend conceded that, I think. C, does the body have any special statutory powers in relation to the function in question? Well, yes, the powers are conferred by measure, but we know, not least because YL tells us, but we know in any event that that by itself plainly can't be determinative. And there are many powers conferred by statute, not least in Aston Cantlow itself, the power being exercised by the PCC, and that does not transform the thing into an exercise of public authority. Factor 4, to what extent is the body supported or subsidised from public funds? The Church essentially isn't supported from public funds. There's a very limited contribution to the Church Conservation Trust, I think it's called, to a very small amount, but otherwise it's not. So that's a no. E, to what extent is the body democratically accountable? Well, these of course relate to the questions in Parliament, to the second Church Estates Commissioner, and I say it's an overreach to call that democratic accountability, but for that maybe they get a half mark. And then F, a flat no. So I'm afraid working through those considerations, we end up in a position where plainly, in my submission, the church commissioners exercising this function aren't doing so as a hybrid public authority. To put that another way, this isn't a public function. I'll address the DMPC while I'm here, although, of course, as I understand it, Ground 1 isn't run against the DMPC, but we're considering DMPC, I think, for Ground 2. I think that's my learned friend's case. My learned friend says that the Diocesan Mission and Pastoral Committee is a public authority because when making the draft proposals, it was exercising statutory powers under the 2011 measure, so that's in paragraph 71 of my learned friend's written case, and I say that should be rejected. The DMPC's relevant functions and duties are set out in sections 1, 3 and 6 of the measure, I took your lordships to them yesterday, but we can open that up again. One is at page 1468. So of course that's the general duty to anyone exercising functions under the measure to have regard to the furtherance of the mission of the Church of England. Section 2 over the page, 1469, relates to the establishment of the DMPC, and then 1470, section 3, the functions of the MPC. And relevantly for this case, and of course it's not said that they're core, we're only thinking about hybrid public authority for the DMPC. It's the function under section 3, sub 3, little f at the top of page 1471, and then we go into section 6, which is what it does under the measure. You have my submission that the mere fact that the powers are conferred under a measure doesn't mean that the body is relevantly exercising a public function. It's constituted, actually taking you to this earlier, sorry, by Schedule 1, which is at page 1598. And one can flick through those provisions. There'll be a person known as the chair of the page. The bishop may be a member and may be the chair. Paragraph 3, unless the bishop is the chair shall be appointed by the bishop, and so on. But we see that the constitution is set out there. Nevertheless, plainly I say, it doesn't transform the exercise of its functions under the measure into public functions for the same reasons effectively that I've already given you in relation to the church commissioners. These functions are not governmental functions, they're not functions that relate to public administration, they're internal church functions concerning the organisation of parishes and benefices. As Lord Nichols said in Aston Cantlow, he said, it smacks of a church body engaged in self-governance. That's at paragraph 14. And I say those words apply very easily to the facts of the present case. So, Mr. Howell says to me in his writing that I should also take you to paragraph 5 of the schedule, which is at page 1602. And that shows that it's the diocesan synod that otherwise determines the membership of the DMPC. So that maybe underlines how much it's a matter for the church authorities and how much it's a matter for the diocesan synod. So those are my submissions on the threshold question, threshold for ground 1 and ground 2, whether the commissioners and the DMPC are public authorities for the purpose of the Human Rights Act and the PSED, and I say that they're not. If I turn then, under issue 5, to the second issue, whether the PCC and Reverend Yvonne Clark have standing. So it's common ground that neither appellant can pursue ground 1 unless, pursuant to section 7 of the Human Rights Act, they would be a victim for the purposes of Article 34 of the Convention. And we cite the reprieve judgment of the former Lord Chief Justice for that proposition in our case. It must be common ground, it's very well known. It's obviously very important that in any human rights challenge, the victim and the negative impact upon them is clearly identified. And in the Statement of Facts and Issues, issue 5, sub 2, page 977, the impact is a disproportionately prejudicial effect on UKME worshippers and local residents by depriving the community of a valuable UKME-led ministry. Now, this is really important because it may well have been the case, or it may not have been the case, that the PCC and the Reverend Yvonne Clark could have brought proceedings relating solely to their own position. Reverend Yvonne Clark could have said, my Article 8 rights are engaged, I say. I'll lose my home, I say. That isn't the claim that's brought. The claim that's brought relates entirely and solely to the impact on the UKME worshippers and local residents. So that's highly relevant to standing because we don't have the direct effect we're used to seeing. And it's also relevant to ambit. And your lordships began to ask questions along those lines this morning. And my position is that the ambit right has to be engaged in the same way as the Article 14 discrimination. So to make that point absolutely plain, it has to be those affected UKME worshippers and local residents whose ambit right is affected in the first place in order for Article 14 to be brought to bear. So far as the PCC is concerned, focusing for present purposes just on victim, and as he said yesterday, of course this point only arises if he satisfies the board on those jurisdictional points and the particular issue 1 which applies to the PCC in particular. But assuming the PCC has standing to appeal and has validly made their appeal, the principle that's relied on to say that the PCC can represent others is the Church of Latter-day Saints case. And he positively relies on it. So the PCC, repeating myself, but the PCC is not an appellant in its own right. It's here exercising a representative function. He relies on the Church of Latter-day Saints case. That's in the authorities bundle at page 3479. The principle's well known, it's not contentious. A religious association may exercise on behalf of its members the rights guaranteed by Article 9 of the Convention, taken alone and in conjunction with Article 14. And we see the same principle stated in How to Name Me, to which I took your lordships a moment ago. It may well be, I think, the origin of this principle was a reading of Article 9, which would have said that only natural persons could hold religious beliefs or convictions. So in order to give those organisations standing, it may be that that's why that approach developed. But in any event, of course we accept and agree with that principle. But in a church such as the Church of England, where there is no single legal personality, and instead a series of entities, it's still, nevertheless, important to ask, in relation to each particular entity, who then do you represent? The representative function is valid under the Church of Latter-day Saints, but who do you represent? So we accept in our written case that the PCC can represent its 12 members as individuals, and we accept that some of those members are UKME residents in the parish. They are, of course, also adherents to the Church, which we need to think about when we get to ambit. But we do accept that. We accept that representative function. My learned friend yesterday conceded, I think, that the PCC can't represent the entirety of the group in relation to which this claim is brought. Those are UKME residents and worshippers. So that means when we get to Reverend Yvonne Clark, she has to represent them in some way, because otherwise they're not represented, the claim fails. The broad claim fails in any event. But he says, okay, well, they represent a narrower group, which are those listed on the church electoral roll. So we've got the church representation rules in the bundle, that's page 1399. And that sets out the entitlement to join a roll. Headed compilation of the roll, page 1399. In every parish there must be a church electoral roll on which the names of laypersons are entered in accordance with this part of the rules. And it sets out that a layperson is entitled to have his or her name on the roll of a parish if they're baptised, aged 16 or over, and have made one of the following 3 declarations and duly applied to enrolment on Form 1. So the first declaration is that you're a member of the Church of England and resident in the parish. The second, a member of the Church of England, or a church, both of them are church and communion with it, not resident in the parish, but habitually attended worship in the parish. And the third declaration, a member in good standing of a church, not in communion, but who subscribe to the doctrine of the Holy Trinity, is also a member of the Church of England and has habitually attended public worship in the parish during the preceding 6 months. So we see, in a sense, the tightness of those declarations, or what they're getting at, essentially, adherence to the beliefs of the Church of England. In this
What's the
particular...
definition of a member of the Church of England?
Wry laughter from behind me.
I see. Somebody who's been confirmed in the Church of
I'll just
England?
take instruction.
Yeah.
No, because it's
This
been continued with
legislation
it.
is, which is this measure?
We provide something after lunch.
Maybe there's no simple answer.
And maybe a simple answer. I've been asked by my learned junior to confirm that this is a schedule, one sees on page 1389, to the Synodical Government Measure 1969. And these are the church representation rules that are scheduled to that measure.
Synodical Government Measure 1969, okay.
Yes, and we see that at the top of page 1389. So we have the most recent statistics for mission for All Saints Spring Park. That's at page 1124. And we have at the top of that page, number on the ecclesiastical electoral roll for your parish, 76. So the PCC, says my learned friend, can represent those 76, and we're prepared to accept that. We have no information as to the ethnicity of those 76 people.
I thought we were shown a paragraph this morning that sort of had a breakdown, or 74 in that paragraph, but wasn't it this? Or was it a different group?
So I think that paragraph relates to the congregation, and it said the congregation is 30.
Oh, well, it was a... I see, sorry.
Yeah, no, it is confusing, and those statistics, as I said when I rose, I think were only presented to the DMPC, but I've looked at them in preparation for this hearing.
And they don't relate to this number here, these numbers, no?
My understanding is they relate to the congregation, but if I'm wrong, then it may well be they relate to this. They also relate to children, in part, don't they, those statistics?
Yes.
And of course, you have to be over 16. We've just seen to be on the electoral roll.
Right.
There's a lack of clarity, I think, about what exactly they relate to.
Yep.
So we're prepared to accept that extension, but nevertheless, essentially I've already made this point to your lordships, we now have those 76 people, but we don't have the 4,300 UK ME people who live in the parish. We have that figure by taking how populous the parish is and then applying the census data on ethnicity. We don't have any way of those persons being represented by the PCC. We turn then to the Reverend Yvonne Clark, and in my submission it's much more difficult to understand how it is that she is said to exercise any kind of representative function. At the outset of my learned friend's submissions yesterday, he referred to a collective harm to the community as a result of the draft scheme. We all know, of course, that in Strasbourg we can't have an actio popularis, that those directly affected are meant to come forward as victims themselves. And we have the limited Church of Latter-day Saints' ability for religious organisation to represent its members, but it's very difficult to shoehorn the Reverend Yvonne Clark into the status of being the relevant religious organisation representing its members. I in no sense would wish to undercut or denigrate her experience of a mutuality of providing ministry and thereby reflectively receiving ministry herself. But I do say that it is, to my knowledge, absolutely unsupported on the authorities, this kind of reflective your harm constitutes my harm, and so I don't need to fit into any of the very limited exceptions to direct harm for victim. If we think of those exceptions, we have Church of Latter-day Saints, we have Lizarraga, which I think we're probably all familiar with, but of course there has to be compelling access to justice reasons why one needs a representative rather than come directly. And this is a case, of course, where there were 40 representations against the measure. Each of those persons obviously could have appealed directly by reference to their own position, and your Lordship, my Lord Hodge, said yesterday that frequently is the case.
These were representations against the draft scheme.
The draft scheme, sorry, I said measure, not scheme, scheme. So I'm afraid we do struggle with this. We don't understand how it is that the Reverend Yvonne Clark is said to represent the position of all UKME residents, 4,300 people in the parish, and the worshippers at All Saints Spring Park. There just isn't a recognised mechanism in convention law that I'm aware of that would allow that to happen. Turning then to whether Articles 8 and 9 are engaged. Now, you'll have seen, in relation to Article 9, we certainly accept and concede that a draft scheme seeks to further the mission of the Church. It seeks to make better provision for the cure of souls. It seems inherently implausible in that sense that it would not have a sufficient connection with the core values of Article 9. We say it's quintessentially a religious measure. And were we to be defending it, were the commissioners to be defending it vis-à-vis the state for some reason, we'd certainly be saying it falls within Article 9. It's a core religious function. So we have that concession. The difficulty which has arisen, and your Lordships will appreciate that now, largely in the course of preparing for the hearing, though I hope you've given due notice of the point, is that we have this internal ambit aspect to Article 9, where when one reads all the cases, one sees repeatedly the Strasbourg court say, a vicar can't come here and complain about a thing which his or her church does, or a parish can't complain about the internal organisation of what happens in their church. So this idea of internal autonomy and the expression of an Article 9 view being that one signs up for a church.
If one could get over the state function point, and the state was taking away from someone the form of worship that they wish to engage in, why would that not be?
Even the premise is difficult in a sense that that's why it's so tied up with public function, because true it is that if the church were part of the state and it were a requirement of domestic law that everyone had to be a member of that state, I suppose.
Well, but why go so far? I mean, I appreciate your submissions in relation to this isn't a public function, so we're engaging with this on the basis that you've lost that argument. But if the relevant state body exercising a public function shut down all the churches in an area so that someone could not easily on a Sunday morning go out to worship in a church of their choosing, but why would that not be within the ambit of Article 9 so far as that person what wishing to worship would be? And here you already emphasised that the representation has to be of a particular group of people who do wish to worship.
My understanding from the cases is it's very much that when one adheres to a religious organisation as a member of the organisation, one signs up to the internal decision-making of the organisation is maybe... Sorry, no, my Lord.
No, you finish, please. Well, just to express a certain amount of doubt about that. I mean, I appreciate one has to get over this, the state engagement issue. But if the state is engaged and makes a decision to withdraw opportunities for worship for a particular group, even though they may have signed up in a certain sense to the church bracket state being able to make these choices, they're still being affected in what they want to do with respect to exercise of their religious life.
Well, so that I can properly think about this over the shorter journey, would your lordship be similarly troubled with a change of liturgy, for example, or a doctrinal matter, or is it because it relates to organisation that it feels more surprising? I'm sorry, it's very impertinent to me to pose a question judicially, but if a person were to say, well, I normally go to this church, but they've begun using a different prayer book, which I don't like, the church as a public authority is the premise for this argument. Could they really bring an Article 9 claim against the church which they've chosen to attend because they no longer like the prayer book? And I'm sorry, again, it's very impertinent style of advocacy to put it this way, but just so
one
that
of the
I can
difficulties is
understand.
there's a slight artificiality here, because I mean the public function point suggests that religion, an organisation that's pursuing religion, is not a public authority.
Absolutely.
And then at the same time, one is then making that assumption and then coming up against the same problem, that if you adhere to a church, you're part of a religious organisation.
Yeah,
So
absolutely.
to respond to your question, I mean, and it's to acknowledge the point that my lord's made and indeed I've made, that it may be a difficult starting point, but if the state body mandated a change in liturgy and someone said, but it's a fundamental part of my religious life that I'm able to participate in the old liturgy, why would that be outside the ambit of Article 9 so far as that individual is concerned?
Can I like you to answer that question? Lord Wood.